that might be needed, or just the normal health care requirements, if they're going to be met. Probably someone in this circumstance should be helped in his the remainder of his lifetime, as other veterans are, through the Veterans Administration, rather than making lump sum settlements of cases like this. We're too far down the pike for that one to be, that sort of thing to be considered in this case. In case anyone brings up the question of the Olson family, where there was an administration of LSD and the gentleman in question there lost his life when he jumped through a window, there is no loss of life involved in this case. There was a larger sum awarded in that case to the widow and 3 children of Mr. Olson, a total of $750,000. And here we're talking about $625,000 for one man who has not lost his life, who has not lost his faculties, who did not appear before the subcommittee in person, who has offered no medical evidence, only psychological testing results to support the claim that's before us. I would urge that the motion of the gentleman from Michigan be supported to refer this matter back to the conferees with instructions that no more than $435,000 be reported back in the conference report.
Gentleman's time has expired. How much time was he? Who has? Gentleman from Michigan has 14 minutes remaining. The gentleman from California has 23 minutes remaining.
The Speaker, I recognize the gentleman from New Jersey, Mr. Hughes, for 5 minutes, and ask him to yield back whatever time he doesn't use.
The gentleman from New Jersey, Mr. Hughes, is recognized for 5 minutes.
My remarks.
Without objection.
Mr. Speaker, we are spending a great deal of time on one private relief bill, but it's an important bill. I respect my colleague from Michigan very much as a very able member of our Judiciary Committee, and I'm sure was a very fine, competent trial lawyer in the days that he practiced law. But the fact of the matter is that the Thornwell case presents some very serious concerns to the United States government. It's a unique case. It's without precedent. The Army wants to get rid of the case for a number of reasons, not the least of which is it's embarrassing. And it could have a profound impact upon our effort to recruit young people into the all-volunteer Army. It's unique in that it has the potential of eroding a very important doctrine, the Ferris Doctrine, which in essence says that members of the armed forces are not eligible to have a waiver of sovereign immunity. And it's also unique to the extent that the government of the United States could be liable for a lot more than $625,000 if the Court of Claims finds in favor of Mr. Thornwell, as they may very well do. Now, I sat as a member of the conference committee and was not at all happy with the fact that we ended up at $625,000. I'm not really sure what the proper amount should be. But the amount that we arrived at was less than satisfactory to our colleagues on the Senate side, as my colleague well knows. We spent more time in this conference haggling about money than we really should in this particular case. Now, the Army and the Justice Department wants to get rid of the case, and for very, very good reasons. And for us to be talking about $625,000 as opposed to what my colleague now wants is $435,000 really doesn't make sense at this point. All parties involved at this point want to settle the case and not have the Court of Claims upset the apple cart, so to speak. Now, I don't know what a jury would have brought in. I can tell my colleague I tried cases like he did for many, many years, and I don't think $625,000 in this instance is totally out of line. I'd be happy to yield.
Yeah, I just want to correct. It's not in the Court of Claims. It's in the United States District Court. It's under the Tort Claims Act, so there will be no jury.
Well, I understand that.
Well, you said the Court of Claims and the jury, and I just
no. There would have been if in fact the Ferris Doctrine had not applied, it had been in the court, the United States District Court, where a citizen would have had access to a jury. And under those circumstances, I don't know what a jury would have returned. In this instance, a jury is not applicable. The gentleman's correct, and I didn't intend to convey that impression. I don't know what a court of claims would award under these circumstances. Now, the gentleman has described in very simplistic terms the psychological and psychiatric problems that this man has had over these years. I frankly don't know at this point what type of deep-rooted problems he's had. The fact of the matter is he had a very severe reaction when LSD was administered to him while he was in the service. And in fact, those that administered it did it for that very reason. That's what makes this case so unique. And LSD has destroyed so many lives that I'm personally aware of, and I'm sure my colleagues are aware of. We still don't totally understand the full impact of the administration of LSD on individuals and what it does to their long-term behavior. So I don't see that anything can be gained at this point by arguing what the impact has been on this man, how it's changed his life. The fact of the matter is, it has in fact had an adverse impact. My colleague acknowledges that something is due him. The only question is, what amount? And I don't think that we're that far off the mark when we try to settle it at this point, so that we don't expose the Ferris Doctrine, so that we don't visit upon the Army any further adverse publicity. And I might say to my colleague from Ohio that under the terms of this settlement, it's in complete settlement of all claims, including veterans' benefits. I yield back the balance of my time. Urge my colleagues
time has
to
expired.
support.
The gentleman from California.
I yield 5 minutes or such portion thereof as he may consume to the gentleman from Kansas, Mr. Glickman.
Mr. Glickman is recognized for 5 minutes.
Thank you, Mr. Speaker. I ask unanimous consent to revise and extend my
Without
remarks.
objection.
I would like to follow up on some of the comments of my colleague from New Jersey. I think there are three issues in this case. One is there responsibility on the part of the Army, even if there is no legal liability? And I think that the answer is yes. We have a man who over 20 years ago was force-fed LSD during the course of an investigation without his consent. And I would like to read a portion of a letter that the General Counsel of the Army wrote to our Chairman George Danielson on December 1st, and I quote, "The circumstances surrounding the prolonged detention and interrogation of Mr. Thornwell, the surreptitious administration of LSD to him in June 1961, and the subsequent failure by the Army to advise him that he had been given LSD or to provide him appropriate care for almost 15 years after the fact are set out in my predecessor's report. Suffice it to say that, due to the unconscionable nature of the wrongs done to him," here is the United States Army saying, due to the unconscionable nature of the wrongs done to him, we feel that the Army has a moral obligation to compensate Mr. Thornwell adequately for his injuries. Both the Department of Justice and the Department of the Army have acknowledged that this man was wronged by being force-fed LSD, and therefore we've made the judgment, yes, there is some responsibility to compensate him. Incidentally, while we have kind of downplayed his condition, the facts indicate that the man has, during this period of time and afterwards, become somewhat of, using this term in as kind a sense as I can, a mental vegetable, and therefore the LSD did have enormous effect. Number two, what should the amount of this compromise be? The House said $250, based upon the gentleman from Michigan's amendment. The Senate said $1 million, based upon the strong effort of the senators, as well as both senators from the state of South Carolina, including Senator Strom Thurmond, the new chairman of the Senate Judiciary Committee. They compromised at $6.25. I agree with the gentleman from New Jersey. I would have liked to have seen it a little bit less, but we're in a classic case where, let me just finish my statement and then I'll yield. We're in a classic case where we have to come with some sort of reasonable compromise. The third item I would say, and this is a point my colleague from New Jersey made so well, is what happens if this case is not settled? What happens if, in fact, Mr. Thornwell is successful in a court of law in getting large amounts of damages from the government of the United States? Not only is the taxpayers lose because the court recovery is much greater, but the real problem is what happens to the thousands of soldiers who have been subjected to chemical testing and nuclear testing and who've had contact with Agent Orange. If, in fact, a court decision would award those soldiers damages as a result of that contact, the liability to the United States would be monumental. And as most of my colleagues know right now, a soldier in uniform is for the most part limited in liability to what he would get under disability and veterans programs. And that, of course, is the doctrine of the Ferez case, is that there is no waiver of that kind of situation. So I'm saying, for all of these reasons, why the amount may be in somewhat of dispute, this Congress owes the taxpayers, I think, an obligation to get the best possible deal given all the circumstances. And I think all those circumstances dictate an acceptance of this conference report. I'd be glad to yield for my colleague from Wisconsin.
I'm somewhat curious in listening to the gentleman's argument why Mr. Thornwell would be deserving of $625,000 given his background and the fact that his injuries have not been completely debilitating, when Dr. Halla Brown received only $400,000 when she was a successful practicing physician in the Washington, D.C. area and was rendered a quadriplegic as a result of an automobile accident.
In the first place, you're talking about the case is substantively entirely different. Dr. Brown was much older than Mr. Thornwell was, but the government was not involved actively in the administration of LSD to Dr. Brown. But I think, again, that we could argue day and night whether it ought to be $400,000, $600,000, $500,000, $700,000. I think that we've established that there is at least some moral responsibility on the part of this government to compensate Mr. Thornwell, who was a young man at the time these injuries occurred, as opposed to Dr. Brown, who was an older woman at the time they occurred. And at the second place, compromise. And we have both senators from South Carolina strongly favoring this legislation. We've split the difference. I think that's an appropriate place for Congress to come down on. I yield back the balance of my time.
Gentleman's time has expired. The gentleman from California has 13 minutes remaining. The gentleman from Michigan has 14 minutes remaining. Gentleman from Michigan.
Yield to the gentleman from Virginia 5 minutes or such part of it as he may use.
Gentleman from Virginia is recognized for 5 minutes.
Thank you, Mr. Chairman. I ask unanimous consent to revise and extend my remarks.
Without objection.
I simply rise in support of the motion of the gentleman from Michigan. I was not privileged to serve on the subcommittee that heard this evidence, but I was present at the deliberations of the Judiciary Committee, and I was, quite frankly, even at that moment felt that $250,000 was excessive under the circumstances. And I've heard nothing today which would alter my view of that. If I could have the attention of the gentleman from California, the chairman of the subcommittee, if I could have your attention for a moment.
I'm most pleased.
Just to help me with my recollection of what took place, did Mr. Thornwell ever appear before your subcommittee and testify in this regard?
Not before my subcommittee.
May I ask the gentleman one more question further? What medical testimony as to the amount of damage was adduced before what medical testimony was adduced? Did any physicians testify?
Would the gentleman yield?
I'd be happy to yield.
I have a summary here. Medical testimony established a claim which would be $587,800, which, coupled with the other testimony of loss of $1,063,000, came to an aggregate of $1,700,000.
I'm not asking for figures. I'm asking you if a physician
if the gentleman yield, I know he didn't ask for the figures, but I thought he might like to have them, and they're free.
Thank you.
No extra charge.
Sure. Could you now go back to my question? I yield to the gentleman to tell us the names of any physicians that testified before his subcommittee.
There were no physicians who testified before my subcommittee. There were physicians who testified elsewhere, and I have the summary of the information.
But so in arriving at this figure, you did not have the benefit of the witness, Mr. Thornwell. You did not examine him to find the degree or of damage to him, or you were not able to judge his demeanor as a result of this experience and all of the psychological damage. You formed no judgments, independent judgments of the claimant before your subcommittee. Is that a fair statement?
Well, the question demands two answers. I was able to form a valid judgment as to the amount, but not from the live testimony of a physician. I had, as is common in the House of Representatives, a great deal of highly credible hearsay testimony. As the gentleman knows, we rarely put witnesses under oath in our committee hearings. We rely upon information supplied to us by affected persons. We did have the information of the United States Army, the Department of Defense, the Department of Justice, all of whom had looked into it. They were very credible, and I relied upon their testimony, as we do in the most important affairs of the House of Representatives.
I thank the gentleman for his response. It seems to me, Mr. Chairman, ladies and gentlemen, that the basis for arriving at a figure here is pretty thin. We have Mr. Thornwell's demeanor, his psychological damage is the basis for the claim, and yet the committee itself did not examine him. The problem is the damage to is a medical question, and yet no physician, no medical doctor testified before the subcommittee. These figures, as to the extent of his damage, are pulled out of the air. I'm not satisfied in my own judgment that we have medical testimony that justifies an expenditure of any great amount. But certainly, the $1 million first suggested by the Senate, the $625 under consideration, far exceeds what is reasonable. So I here, because it's the only opportunity I have to reduce the amount of this judgment, the suggested figure, I support the motion of the gentleman from Michigan and would urge my colleagues to do likewise.
Gentleman's time has expired. Gentleman from Michigan has 9 minutes remaining.
I yield myself 5 minutes or such part of it as I may use.
Mr. Sawyer, gentleman from
Let
Michigan.
me just make a little additional point to the colloquy that just occurred between the gentleman from Virginia and the gentleman from California. There is no medical testimony either in the House records or in the Senate. Nobody ever saw this man. All that we have is the psychologists, PhDs, who are hired by his lawyers. Now, normally you might rely on the Army or the Department of Defense. But in this case, as I said when I first spoke, they are so humiliated by their behavior in this situation some 20 years ago that they would like to see any amount of taxpayers' money put out to quiet this thing down and have it go away. They're not willing to do anything out of their own budget, but they're perfectly delighted to see anything we're willing to pay to get rid of it. So they have a very self-interest in this situation, and therefore are not really as reliable as they might be under other circumstances. Let me just read directly from the report of his own testing psychologist hired by his lawyers when we hear such statements as we did from the gentleman from Kansas that this man's a vegetable. And bear in mind, we're talking about compensation for injury, not punitive damages against anyone for their behavior. It says, according to psychological examination, he has an intelligence which is classified as bright normal at approximately the 82nd percentile of the population. Further, the psychological test results also do not point strongly in the direction of diagnosing organic brain damage. Further, reading directly from his own testing psychologist, forensic psychologist reports, tests of memory indicate no significant memory loss. And when it boils it down, he just does not like permanent associations, particularly with work. And he's held a number of different jobs for periods of 3, 4, 6 months and quit and went back on the beach. He prefers his own company to that of other people. This is what the damages are, and when we are even talking $250,000, I don't know of any court of law, and here it's not going to be a jury, and it's not going to be the Federal Court of Claims, it's going to be the United States District Court, that would award anything that looks like $250,000 for that kind of attitude, a bad attitude. Sometimes I get a bad attitude. This guy apparently has kind of a permanent bad attitude. but he's certainly not a vegetable. He's in the 82nd percentile of the entire population. No memory loss, no organic brain damage, no medical, not one whit of medical testimony, and the medical literature does not indicate that bad attitudes flow from LSD. Flashback things where people all of a sudden might do something impulsive or literally crazy do, but not just a permanent bad attitude vis-a-vis holding a job or working, which is, and it seems to me when we're talking, and you know, you say lightly, what's $200,000 one way or the other? Well, to the American taxpayer, the individuals, $200,000 is a lot of money. And while it's all right to compensate damages, to just make an award to avoid the embarrassment to the Army and sweep this thing under the rug without one scintilla of medical evidence to support the damages, even his own psychologists merely say, you know, he's got a bad attitude, but everything else is fine. No tie-in with LSD, which anyway a testing psychologist couldn't do because he's not qualified to do and would not be permitted to do. And the medical literature indicates this kind of symptoms is not related in any history in medical literature to the ingestion of LSD. It's just a plain bad attitude. Apparently, maybe the same attitude that impelled the guy to walk out of college when he had a full-ride scholarship, impelled the guy to steal and throw in the river Army documents, and lets him live on the beach in California. It just seems to me that when I am willing to go to $435,000, I gag on that. But $625,000 of American taxpayers' money, tax-free to this guy with a bad attitude, because of something the Army wants to sweep under the rug, I still think is absolutely outrageous, and I even feel bad about the $425,000.